you. Please be seated. Has the state received a copy of the court's instructions to the jury?
Yes, Your Honor.
As a defense?
Yes, Your Honor.
Does the state take any exception pursuant to CRRLJ 6.15B, take any exception to the instructions the court has given?
Your Honor, I have a quick question I just need to discuss with counsel.
Of course.
Just looking at 8 and 13 and seeing if they are, oh, I see. Oh, no, I think that's good. Okay. No, Your Honor, no objections or exceptions.
Okay, so the state is not taking exception to the instructions given. Is the state taking exception to any instructions that were not given?
No, Your Honor.
To the defense, pursuant to CRRLJ 6.15B, does the defense take any exception to the instructions that are given?
We take all exceptions previously argued and incorporate all argument. Other than that, no.
And similar to the instructions that were not given?
Same
Similar
answer.
argument?
Same answer, yes.
Do you have any comment?
No, Your Honor.
All right, and the court will also rely upon its rulings on the prior matters that we've already discussed. Is the state ready to proceed with reading of the instructions to the jury and closing
Yes,
argument?
Your Honor.
Defense ready?
Yeah, you're ready, Your Honor, but we understand there's a PowerPoint. We've asked to see it, and that's, our request has been refused. But we would ask the court if we could see the PowerPoint for closing.
In advance? Is that what you're asking?
Your Honor.
Steve?
I don't think that's appropriate at all. It's like showing them my notes as well.
Defense? Any
Your Honor, it's
authority?
material that's being shown to the jury. We don't know what's in it or anything else, so we'd like to see it. I think it would be a courtesy, and of course, there's always an exchange for opening statements for other reasons, I understand, but I don't see any harm in showing it to us, and we've made the request, so we're asking the court the same thing.
Any authority you want to present to the court
On closing arguments?
in support of
Well, I mean,
your request to have the PowerPoint that the state's going to show be shown to you in advance?
I don't have a case that says that you have to show a PowerPoint, but I think that it's a professional courtesy. If we had a PowerPoint, we would do the same. There are cases, of course, as the court knows, on opening statements.
Yes, sir.
Thank you.
Yeah, it would be like showing them my notes. I mean, whether or not I'm verbally saying something or putting words on a screen, to me, there's no distinction there, and I don't think I should have to have them review my closing argument before I give it.
The defense motion is denied. This is not opening statement, and I'm aware of some of the case law that the council has cited on with respect to opening statement. This is closing argument, so the lacking any authority in support of the defense request, it's denied. So is the defense ready to proceed with reading of the instructions and closing?
We are, Your Honor. Thank you.
We'll give some leeway with respect to when the afternoon recess should be taken. We start a little bit late as well, but it wouldn't be fair for the jury to go to 4:15, and so we need to take one at some point. But we'll see where we are with respect to the timing of that. I think we talked about this early on, but if not, I do want to tell you now that the court has not been asked to put a limit on time with respect to closing arguments. I've not been asked to do it, so I won't do it. And so the time you want to take is yours to take on closing for each side and then rebuttal closing.
Thank you, Your Honor.
Thank you, Your Honor.
Please bring the jury back. Copies of the jury instructions are sitting on the jurors' seats along with their notes, so they have copies, so they'll be able to read along if they want, or not if they want. That's really up to them.
Thank you, Your Honor. Thank you, Your Honor.
Will the the state be ready to go into closing right after I finish reading the instructions? Or-
Yeah, sure.
The jury is returning to the courtroom. Thank you. Everyone may be seated. Members of the jury, on your chair are two items. One are your notebook that you may or may not be taking notes on, and the second is a document that's titled Court's Instructions to the Jury. The law requires that I read these instructions out loud to you. You also have copies of the same instructions, so if you want to read along, that's fine, but that's why you have copies. And these are the Court's Instructions to the Jury. Instruction number 1. It is your duty to decide the facts in this case based upon the evidence presented to you during this trial. It is also your duty to accept the law for my instructions, regardless of what you personally believe the law is or what you personally think it should be. You must apply the law from my instructions to the facts that you decide have been proved, and in this way decide the case. Keep in mind that a charge is only an accusation. The filing of a charge is not evidence the charge is true. Your decisions as jurors must be made solely upon the evidence presented during these proceedings. The evidence that you are to consider during your deliberations consists of the testimony that you may have heard from witnesses and the exhibits that I have admitted during the trial. If evidence was not admitted or was stricken from the record, then you are not to consider it in reaching your verdict. Exhibits may have been marked by the court clerk and given a number, but they do not go with you to the jury room during your deliberations unless they have been admitted into evidence. The exhibits that have been admitted will be available to you in the jury room. One of my duties has been to rule on the admissibility of evidence. Do not be concerned during your deliberations about the reasons for my rulings on the evidence. If I have ruled that any evidence is inadmissible, or I have asked you to disregard any evidence, then you must not discuss that evidence during your deliberations or consider it in reaching your verdict. Do not speculate whether the evidence would have favored one party or the other. In order to decide whether any proposition has been proved, you must consider all of the evidence that I have admitted that relates to the proposition. Each party is entitled to the benefit of all of the evidence, whether or not that party introduced it. You are the sole judges of the credibility of each witness. You are the sole judges of the value or weight to be given to the testimony of each witness. In assessing credibility, you must avoid bias, conscious or unconscious, including bias based on religion, ethnicity, race, sexual orientation, gender, or disability. In considering a witness's testimony, you may consider these things: the opportunity of the witness to observe or know the things he or she testifies about, the ability of the witness to observe accurately, the quality of a witness's memory while testifying, the manner of the witness while testifying, any personal interest that the witness might have in the outcome or the issues, any bias or prejudice that the witness may have shown, the reasonableness of the witness's statements in the context of all of the other evidence, and any other factors that affect your evaluation or belief of a witness or your evaluation of his or her testimony. The lawyer's remarks, statements, and arguments are intended to help you understand the evidence and apply the law. It is important, however, for you to remember that the lawyer's statements are not evidence. The evidence is the testimony on the exhibits. The law is contained in my instructions to you. You must disregard any remark, statement, or argument that is not supported by the evidence or the law in my instructions. You may have heard objections made by the lawyers during trial. Each party has the right to object to questions asked by another lawyer and may have a duty to do so. These objections should not influence you. Do not make any assumptions or draw any conclusions based on the lawyer's objections. Our state constitution prohibits a trial judge from making a comment on the evidence. It would be improper for me to express, by my words or conduct, my personal opinion about the value of testimony or other evidence. I have not intentionally done this. If it appeared to you that I indicated my personal opinion in any way, either during trial or in giving these instructions, you must disregard this entirely. You have nothing whatever to do with any punishment that may be imposed in case of a violation of the law. You may not consider the fact that punishment may follow conviction, except insofar as it may tend to make you careful. The order of these instructions has no significance as to their relative importance. They are all important. In closing arguments, the lawyers may properly discuss specific instructions. During your deliberations, you must consider the instructions as a whole. As jurors, you are officers of this court. You must not let your emotions overcome your rational thought process. You must reach your decision based on the facts proved to you and on the law given to you, not on sympathy, prejudice, or personal preference. To assure that all parties receive a fair trial, you must act impartially with an earnest desire to reach a proper verdict. Instruction number 2. A separate crime is charged in each count. You must decide each count separately. Your verdict on one count should not control your verdict on any other count. Instruction number 3. The evidence that has been presented to you may be either direct or circumstantial. The term direct evidence refers to evidence that is given by a witness who has directly perceived something at issue in this case. The term circumstantial evidence refers to evidence from which, based on your common sense and experience, you may reasonably infer something that is at issue in this case. The law does not distinguish between direct and circumstantial evidence in terms of their weight, their weight or value in finding the facts in this case. One is not necessarily more or less valuable than the other. Instruction number 4. The defendant has entered a plea of not guilty. That plea puts in issue every element of each crime charged. The state is the plaintiff and has the burden of proving each element of each crime beyond a reasonable doubt. The defendant has no burden of proving that a reasonable doubt exists. A defendant is presumed innocent. This presumption continues throughout the entire trial unless, during your deliberations, you find it has been overcome by the evidence beyond a reasonable doubt. A reasonable doubt is one for which a reason exists and may arise from the evidence or lack of evidence. It is such a doubt as would exist in the mind of a reasonable person after fully, fairly, and carefully considering all the evidence or lack of evidence. Instruction number 5. A person commits the crime of false reporting when, with knowledge that the information reported, conveyed, or circulated is false, he or she initiates or circulates a false report or warning of an alleged occurrence or impending occurrence, knowing that such false report is likely to cause an emergency response. Instruction number 6. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result which he or she is aware of that fact, circumstance, or which he or she is aware of that fact or circumstance. That fact, circumstance, or result. Let me read that sentence again. A person knows or acts knowingly or with knowledge with respect to a fact, circumstance, or result when he or she is aware of that fact, circumstance, or result. It is not necessary that the person know that the fact, circumstance, or result is defined by law as being unlawful or an element of a crime. If a person has information that would lead a reasonable person in the same situation to believe that a fact exists, the jury is permitted but not required to find that he or she acted with knowledge of that fact. Instruction number 7. Emergency response means any action to protect life, health, or property by a peace officer or law enforcement agency of the United States, the state, or a political subdivision of the state. Instruction number 8. Cities and counties are political subdivisions of the state. Instruction number 9. To convict a defendant of the crime of false reporting, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about January 27, 2021, the defendant initiated or circulated a false report or warning of an alleged occurrence or impending occurrence. 2. That the defendant knew that the information reported, conveyed, or circulated was false. 3. That the defendant knew that the false report was likely to cause an emergency response. And 4. That this act occurred in Pierce County, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 10. A person commits the crime of making a false or misleading statement to a public servant when he or she knowingly makes a false or misleading statement to a public servant. Instruction number 11. A material statement is a written or oral statement reasonably likely to be relied upon by a public servant in the discharge of his or her official powers or duties. Instruction number 12. Public servant means any employee of government. Instruction number 13. Government includes any branch, subdivision, or agency of the government of this state and any county, city, district, or other local governmental unit. Instruction number 14. To convict the defendant of the crime of making a false or misleading statement to a public servant, each of the following elements of the crime must be proved beyond a reasonable doubt. 1. That on or about January 27, 2021, the defendant made a false or misleading statement to a public servant. 2. That the statement was material. 3. That the defendant knew both that the statement was material and that it was false or misleading. And 4. That this act occurred in Pierce County, Washington. If you find from the evidence that each of these elements has been proved beyond a reasonable doubt, then it will be your duty to return a verdict of guilty. On the other hand, if, after weighing all of the evidence, you have a reasonable doubt as to any one of these elements, then it will be your duty to return a verdict of not guilty. Instruction number 15. When you begin deliberating, you should first select a presiding juror. The presiding juror's duty is to see that you discuss the issues in this case in an orderly and reasonable manner, that you discuss each issue submitted for your decision fully and fairly, and that each one of you has a chance to be heard on every question before you. Deliberations are to occur only in the jury room when all 6 jurors are present. You all are all officers of the court and must evaluate the evidence with an open and mind free of bias or prejudice. If during your deliberations you become concerned that the discussions are being influenced by preconceived bias or prejudice, you must bring this to the attention of the other jurors so that the issue may be fairly discussed among all members of the jury. During your deliberations, you may discuss any notes that you have taken during the trial if you wish. You have been allowed to take notes to assist you in remembering clearly, not to substitute for your memory or the memories or notes of other jurors. Do not assume, however, that your notes are more or less accurate than your memory. You will need to rely on your notes and memory as to the testimony presented in this case. Testimony will rarely, if ever, be repeated for you during your deliberations. If, after carefully reviewing the evidence and instructions, you feel a need to ask the court a legal or procedural question that you have been unable to answer, write the question out simply and clearly. For this purpose, use the form provided in the jury room. In your question, do not state how the jury has voted. The presiding juror should sign and date the question and give it to the bailiff. I will confer with the lawyers to determine what response, if any, can be given. You will be given the exhibits admitted in evidence, these instructions, and verdict forms for recording your verdict. Some exhibits and visual aids may have been used in court but will not go with you to the jury room. The exhibits that have been admitted into evidence will be available to you in the jury room. You must fill in the blank provided in each verdict form the words not guilty or the word guilty according to the decision you reach. Because this is a criminal case, each of you must agree for you to return a verdict. When all of you have so agreed, fill in the verdict forms to express your decision. The presiding juror must sign the verdict forms and notify the bailiff. The bailiff will bring you into court to declare your verdict. I'm almost done. Instruction number 16. As jurors, you have a duty to discuss the case with one another and to deliberate in an effort to reach a unanimous verdict. Each of you must decide the case for yourself, but only after you consider the evidence impartially with your fellow jurors. During your deliberations, you should not hesitate to re-examine your own views and to change your opinion based upon further review of the evidence and these instructions. You should not, however, surrender your honest belief about the value or significance of evidence solely because of the opinions of your fellow jurors. Nor should you change your mind just for the purpose of reaching a verdict. The final 2 pages are the verdict forms that the court's already discussed. And during closing argument, you are not permitted to take notes, so please do not do that. At this time, members of the jury, please give your attention to the closing argument of the prosecution. Ms. Tratnik?
Thank you, Your Honor. Good afternoon. Thank you for your careful attention throughout this entire case. On January 27th, 2021, Sheriff Ed Troyer made a direct call to a 911 dispatcher and told that dispatcher that someone who knew he was a police officer had just threatened to kill him. That statement was a lie, and not just any lie, but a lie that caused over 40 law enforcement officers to rush to the scene to protect Sheriff Troyer. This lie wasted the shared law enforcement resources of Pierce County, and it terrorized a newspaper delivery man who was just trying to earn a living. And that's what brings us here today. Now, the facts of this case are fairly simple. I've got a few PowerPoints here to help me and to help you, and we tried to kind of move things around in this court so you could see them when they project up there. If we haven't done that perfectly and a few of you can't see them perfectly, that's okay, because I'm going to be talking about them. Now, Cedric Altheimer has been delivering newspapers since he was 16 years old. He's now 25. On January 27th, 2021, he went to a North End Tacoma neighborhood to deliver a couple hundred newspapers. It's the same neighborhood he's been delivering papers to for a couple of years. And on that night, as he's delivering his papers, the defendant, driving a personal vehicle, begins following him through the neighborhood. And the defendant continues to reappear over and over again, and Mr. Altheimer becomes concerned. So he walks up to the defendant and he asks him, "Why are you following me? Are you a cop?" And how does Sheriff Troyer in his personal vehicle respond? Does he say, "Hey, I live in the neighborhood, I just want to make sure everything's okay here. I saw you driving around, is there something I can help you with?" No. Instead, Sheriff Troyer refuses to identify himself, and he accuses Mr. Altheimer of being a porch pirate. So Mr. Altheimer leaves. Now, Mr. Altheimer testified that the defendant continued to follow him, and the defendant testified that he didn't. But what's undisputed is that Mr. Altheimer left and that the defendant did not. The defendant could have ended this whole thing right then and there and gone home, but he didn't. Now, Sheriff Troyer was the public information officer for the Pierce County Sheriff's Office for 2 decades, the face and the voice of the department's messenger to the public. He had just finished running a successful campaign for sheriff. This is a man who understands the power of words and how to message things. So while safely seated in his SUV, Sheriff Troyer makes a direct call to a 911 dispatcher, identifies himself, and knowing the effects that his words will have, he tells the dispatcher this. Yes.
House and I caught some in my driveway,
Oh,
and just threatened to
let me
kill him, and they blocked him in. He's here right now.
Okay. Go again with.
Okay, I'm trying to get back to the beginning of that.
Radio.
Hey, it's Troyer.
What can I do for you?
I'm at 27th and Deidre in Tacoma, in North End. About 2 blocks from my house, and I caught some in my driveway. He just threatened to kill him, and they blocked him in. He's here right now.
Okay.
Relying on what Sheriff Troyer told him, dispatcher Conrad Shadell believed that the sheriff was in an active confrontation with a man outside his home who knew he was a police officer. Mr. Shadle typed in the information the sheriff had given him. This information was then seen by fellow dispatcher Leah Heiberg, who was dispatching to North Tacoma that night. And she immediately toned out Sheriff Troyer's call as a code 0, the highest priority code reserved for when a police officer's life is in danger or when the mountain explodes. You can see the timestamps on here. This is what Mr. Shadle testified to.
Objection, Your Honor, the CAD.
This is
That's
what,
not admitted, Your Honor.
this is what he testified to. He testified to the first 4 lines of the CAD verbatim.
Your Honor, not to the seconds like we see up there. I object, it's not in evidence.
He did.
With respect to the slide.
Mr. Shadle typed in the information that Mr. Troyer had called in and said that someone had threatened his life. 4 minutes and 38 seconds elapse before
Right,
Now-
I'm sorry, I object. The call transcript is likewise not in evidence.
he testified to these stamps. He testified to this specific time frame.
Overruled.
Thank you, Your Honor. That's verbatim.
During the 4 minutes and 38 seconds before Officer Lawless downgrades the call, over 40 officers began responding to Sheriff Troyer's call, trying to get there in time to save the life of a fellow officer. And all of these officers would have arrived at the scene had Officer Lawless not quickly realized that the situation was not as the defendant had described. During the less than 5-minute call that followed, Sheriff Troyer told Mr. Shadle 4 times with specificity that Mr. Altheimer had threatened to kill him. I'm at 27th and Deirdre in Tacoma, North End, about 2 blocks from my house, and I caught someone in my driveway who just threatened to kill me. And I blocked him in. He's here right now. He knows who I am, and he threatened to kill me. I'm glad we're a couple blocks from my house. He said he would kill me. So he ... Mr. Shadle responds, "Yikes, do you hear the officers?" I tried to be polite to him, and he just says I'm a racist, and he wants to kill me. As jurors, you don't check your common sense at the door, you bring it with you, and just like throughout your daily lives, where you rely on common sense to make sense of the world and to make important decisions to get you to rely on that here too. So ask yourselves, does it make sense that Mr. Altheimer would threaten to kill Sheriff Troyer? This is a man who's been delivering newspapers for 8 years. He's worked this particular route for 2. He's been repeatedly stopped by uniformed officers during his route, and while that might be inconvenient and annoying, it's not surprising and it's not unexpected. And he knows that that comes with the territory. And if he wants to keep delivering newspapers and pay his bills, he's not going to threaten to kill somebody in the middle of his route in the very neighborhood that he knows he's going to have to come back to the next day, the next day, and the next day to continue doing his job and earning a living. I submit to you that it simply makes no sense for Mr. Altheimer to interrupt his newspaper route and threaten to kill someone. Anyone, let alone someone he suspects might be a police officer. Someone who, as he later told Officer Ventura, carries a gun and could arrest or even shoot him. And what makes even less sense is the animated testimony that you saw from the defendant, claiming that when he pulled up and before his car had even come to a complete stop, that Mr. Altheimer just began indiscriminately yelling and threatening at him and waving his arms and pounding on the hood of his car for no other reason than the mere fact that Sheriff Troyer pulled up in his car. And I submit to you that the reason none of that makes sense is because that's not what happened. Sheriff Troyer was never threatened. He was disrespected. Sheriff Troyer is charged in count 1 with false reporting and in count 2 with making a false or misleading statement to a public servant. And both of these charges boil down to this. Did Cedric Altheimer threaten to kill Sheriff Troyer? This is in your jury instructions. These are the elements of the first charge, which is false reporting. That on or about the date in question, the defendant initiated or circulated a false report or warning of an alleged occurrence or impending occurrence. That the defendant knew that the information reported, conveyed, or circulated was false. That the defendant knew that the false report was likely to cause an emergency response and that the acts occurred in Pierce County, Washington. Element 4 is Pierce County, Washington. This is undisputed that Sheriff Troyer called from this Tacoma neighborhood, which is in Pierce County, Washington. The call was also received at South Sound 911, which is also in Pierce County, Washington. Now, element 1 is that the defendant initiated or circulated a false report or warning of an alleged occurrence or impending occurrence. The alleged occurrence here is Sheriff Troyer's claim that someone had threatened to kill him. Now, what you notice on here is the defense has made a constant point throughout this trial that Sheriff Troyer never dialed the numbers 911. But as you can see, calling 911 isn't even an element of this crime. One can circulate a false report or an alleged occurrence in multiple ways by posting something on social media, emailing or calling a business, a sporting event, a school, an airport, any place where people congregate, and falsely claiming that those places and or the people inside of them are in some type of danger that requires an emergency response. So it doesn't matter who the defendant called here, it just matters that he initiated this false report. Now, having said that, let's be clear about what happened here. There are 2 ways to get a call into South Sound 911. One is to dial 911, which gets you to the comm officer that then screens the call, and then and only after that is done is that then forwarded to the dispatcher. The second way is what Sheriff Troyer used, which is he called the officer backline. that gets you directly and more quickly into the dispatcher, the person who has the ability to actually send the police. Now, I'm going to discuss elements 1 and 2 together, that the defendant initiated or circulated a false report or warning of an alleged occurrence, and that he knew that that information was false. In other words, that the defendant repeatedly told Mr. Shadle that Mr. Altheimer had threatened to kill him when he knew that that's not what had happened. So what is the evidence that proves beyond a reasonable doubt that Sheriff Troyer lied to 911 when he repeatedly claimed that someone had threatened to kill him? Well, for starters, Sheriff Troyer admitted that when he allegedly heard Mr. Altheimer say, "I'm going to take you out," that he didn't even know what that meant. What he testified to is, "I think he wanted to take me out and fight, or kill me, or something, or I don't know. He was so angry." And yet, Sheriff Troyer explicitly said 4 times that someone had just threatened to kill him. This isn't some kind of misspeak. Sheriff Troyer's words are unambiguous. Someone has just threatened to kill me. And what's as important as what he says on the call is also what he doesn't say. He never says, "I need someone to come calm things down." He never says, "There's someone here who looks like he wants to fight." He never says, "There's someone here who says he's going to take me out." You don't hear any of those words anywhere, or words to that effect, anywhere in this nearly 5-minute call. Let's turn to the testimony of Officer Hobbs. Now, as I discuss the testimony of all the witnesses, I'd simply like you to keep in mind jury instruction number 1, which tells you that you are the sole judges of the credibility of witnesses, and it gives you some criteria or factors that you can consider when judging credibility, and that's a non-exclusive list, so there may be other factors that you come up with as well. So let's go back to Officer Hobbs, who testified a couple weeks ago. So Officer Hobbs, like the rest of the officers, drove code to protect a fellow officer from an alleged death threat. So when he walks over to Sheriff Troyer and he asks him what happened, because he wants to know what made Sheriff Troyer call in a threat to his life. And Officer Hobbs testified to 3 basic things. Number 1, that he remembers Sheriff Troyer telling him that he saw a man with a flashlight and a garage door opener, followed him, and then the man cussed at him. And he testified that that's all that Sheriff Troyer told him. Officer Hobbs testified that Sheriff Troyer never mentioned a threat to him on scene, never mentioned a threat to his life, nor did he even express any fear. Number 2, that he can hear himself on his body camera saying there was no gun, no threat. At one point he says he's going to kill me, but when we asked him again, he didn't say that. And then he and Officer Barron go and they talk about having followed newspaper delivery guys in the past. Number 3, Officer Hobbs repeatedly testified that while he can hear himself saying that on the body camera, he doesn't know why. He said that part about at one point he says it's going to kill me, but he does know that on scene Sheriff Troyer never mentioned a threat to his life, nor did he express any fear. Now remember that Officer Barron, who was the passenger as Officer Hobbs was driving, is relaying information from the CAD and from what they can hear and what can be read on the CAD as they're rushing to the scene. He's relaying that to Officer Hobbs. And Mr. Shadle testified that what he typed in into the CAD
Sustained.
was that Sheriff Troyer was calling in and claiming that someone had threatened his life. Troyer calling in stating male subject, making threats to kill him. Sound familiar? So what makes sense is that Officer Hobbs' reference to, at one point he said he's going to kill me, is a reference to the information he received on the way to the scene. And when we asked him again, we being TPD, he didn't say that, meaning he denied Sheriff Troyer ever being threatened. And regardless, the statement ends with Officer Hobbs' conclusion that Sheriff Troyer said he wasn't threatened. And also consider this. Officer Barron and Officer Hobbs are partners who work and socialize together on a regular basis. And remember Officer Barron's testimony a couple weeks ago when he was asked, why did you send a text calling Sheriff Troyer a douchebag? And Officer Barron's response was, because if it weren't for the actions of Sheriff Troyer that night, we wouldn't all be here. Officer Lawless. So now Officer Lawless goes over to Sheriff Troyer to ask him what happened, because he too wants to know, why are we all here? What is the threat? And Officer Lawless isn't some rookie cop. At this point, he'd been an officer for about 18 years. He was the squad specialist. He's since been promoted to detective in the robbery and the homicide division. And when he goes to talk to Sheriff Troyer, he's there to find out one thing, and one thing only. He needs to determine, did Mr. Altheimer threaten to kill the sheriff? And here again, given the opportunity to tell Officer Lawless about the threat on his life, Troyer again fails to mention any threat, and instead just complains about what he views as Mr. Altheimer's suspicious driving. Officer Lawless then specifically and pointedly asks Sheriff Troyer, were you threatened? And when he says no, which was not what the dispatchers had said to the officers responding to the scene, Officer Lawless needs to make sure that he has heard that right, because it is contrary to what he heard from 911. So he asks a second time, did he ever make any threats towards you? Did he ever display any weapons? And again, Sheriff Troyer says no. So Sheriff Troyer doesn't even bring up these threats on his own, and even when he is specifically asked about them twice, he says no. But it was clear that Mr. Altheimer wanted to fight. But looking like you might want to fight isn't at all the same as threatening to kill someone. And it's not what he told Mr. Shadell on the 911 call. And how else do you know that Sheriff Troyer's statements to Mr. Shadell that Mr. Altheimer had threatened to kill him were a lie? Because when Officer Lawless tells Sheriff Troyer that Mr. Altheimer was just delivering papers on his regular route, Sheriff Troyer says, oh, let him go. And I submit to you that if Mr. Altheimer had actually threatened to kill Sheriff Troyer, there is no way Sheriff Troyer would have told Officer Lawless to let him go, spring him loose outside my home 30 minutes after he just threatened to kill me. And when asked by Sergeant Blair, should we park a car outside your home to keep you safe, Sheriff Troyer again says, no. These are not the words and actions of a man who was just threatened with death. These are the words of a man who, when he learns that this guy that he was following around the neighborhood had a legit reason to be there, realized that he had kind of stepped in it and wanted it to quietly go away. This man that he had accused without evidence of being a porch pirate. And these are also the words of a man who, when he is done teaching Mr. Altheimer a lesson, that there's no more reason to take this any further. So let him go. Now the defense may get up here and they'll say, oh, well, gosh, if only Officer Lawless hadn't forgotten to grab his body camera out of the Charger as he was sprinting out of the substation to save the life of a fellow officer. Then this conversation between Officer Lawless and Sheriff Troyer would have been recorded. And that's true. It would have been recorded. But I submit to you that arguing that that matters is a red herring. Now, notably, TPD had just gotten these body cameras 3 weeks earlier, and they were not even required to wear them at the time. So is the defense saying that if this had occurred 3 weeks and 1 day earlier, then the state couldn't possibly prove its case because without a recording, there can't possibly be enough evidence? No. Jurors are tasked with judging the credibility and testimony of all witnesses. That's front and center in jury instruction number 1. And I submit to you that there is no way Officer Lawless got this conversation wrong. He was there to determine one thing and one thing only: was the sheriff's life threatened? That is a hugely important thing, and it's not something you're going to risk getting wrong. You would never walk away from this scene without being absolutely sure to get this life and death situation right. And Officer Lawless, and any officer for that matter, would have never released Mr. Altheimer without first making sure that there was no threat to Sheriff Troyer, no threat to the life of a fellow officer. Now, in this trial, you also heard from Mr. Altheimer, and consistent with what he said to the officers on the scene, and consistent with what Sheriff Troyer told Officer Hobbs and Officer Lawless, Mr. Altheimer testified that he never threatened Sheriff Troyer. Now, Mr. Altheimer had no reason to threaten to kill the sheriff who, as he said to Officer Ventura, the sheriff, someone who has a gun on him? And when you're able to watch Mr. Altheimer at length on Officer Ventura's video, you can hear and see that he's there to complete a job that he's been doing for 8 years. He's got baby formula in the car, he's got a couple of hundred newspapers that still need to be delivered, and he needs to get home. And again, it just makes no sense that he's going to interrupt that in a neighborhood that people can identify him, that he has to keep returning to stop and threaten the sheriff. And I submit to you that the reason that makes no sense is because that's not what happened. Now, the defense made a point of questioning Mr. Altheimer about the fact that he's filed a civil lawsuit. Okay? Now, I want to be clear here that the state is not criticizing the actions of these responding Tacoma police officers. On the contrary, these TPD officers ran to their cars and drove code to protect a fellow officer that they were told had just had his life threatened. And they approached a driver who they were told was the source of that lethal threat. And you can see for yourselves on Officer Ventura's body camera that these responding officers handled that high adrenaline situation with exceptional courage, skill, and professionalism. Now, unfortunately, that doesn't change what Mr. Altheimer endured as a result of Sheriff Troyer's lie. On the body camera, you can hear, as Mr. Altheimer's in his car, you can hear the sirens from other vehicles, police vehicles that are still descending on this scene. He's being yelled at to keep his hands in sights. There's 4 officers, 2 coming from the front, 2 coming from the back, and he knows he better keep his hands in sight. The situation of the police surrounding and detaining him was obviously terrifying and humiliating. And when Officer Ventura then tells him that the reason everybody's here is because he's the sheriff, Mr. Altheimer believes that there isn't going to be any accountability for what has just happened to him. So he files a lawsuit.
Excuse me, to remind the jurors, do not take notes during closing argument.
Thank you, Your Honor. Now, some of you, this lawsuit, some of you may think that's a good thing, some of you may think that's a bad thing, and some of you may have no feelings about that one way or the other. But what matters for purposes of this trial is whether that affects your assessment of Mr. Altheimer's credibility. And I submit for your consideration that wanting to redress and seek compensation for this truly unfair and terrible thing that happened to him doesn't impact his credibility. Why? Because Mr. Altheimer remained consistent this entire time. He simply is coming in here and telling you the same things that he told the officers on scene that night, which is that he never threatened Sheriff Troyer, a fact corroborated by the testimony of Officers Hobbs and Lawless. Now, the defense and Sheriff Troyer were also sure to make a big show of how Mr. Altheimer acted when the police rolled up on him. Oh gosh, look how mad he is. He's so scary. That's how he looked when I first saw him in the first encounter. No, even worse. Well, several things about that. These are two different points in time, and I understand that they're only, 5-10 minutes apart. But it is a completely different situation to have somebody roll up on you in a personal vehicle during your newspaper route than it is to be sitting in your car, having police sirens wailing, having multiple officers, 3 with their guns out, approaching your car. There's not a lot of time between those two, but those are two completely different situations, and it is not reasonable to claim, well, what he looked like there must have been what he looked like before. Ask yourselves and discuss with your fellow jurors, are the emotions that you see Mr. Altheimer expressing on that video, are they unreasonable? And are they surprising? And are those emotions even frightening to see? Let alone as terrifying as Sheriff Troyer, a decades-long law enforcement officer, claims that they were to him. The testimony of Sheriff Troyer and the words on the 911 call. Again, you're the sole judges of the credibility of witnesses, and factors to consider include the quality of a witness's memory while testifying, the manner of the witness while testifying, and the reasonableness of the witness's statements in the context of all of the other evidence. Now, I understand that some time has gone by since these events, but the important parts of these events that Sheriff Troyer experienced should be memorable. Sheriff Troyer testified that while he was on the phone with Mr. Shadle and waiting for the police to arrive, that he and Mr. Altheimer were about 20 feet apart, and he said that they were outside of their vehicles, and that Mr. Altheimer was continuing to scream and yell at him. Now, remember on the call, what he says to Mr. Shadle is, we're in a stare down, okay? I'm backing up and he's pushing against my car. These are present sense statements which could not have happened if the two men were allegedly outside their vehicles. The photos that Mr. Altheimer took, we submitted those into evidence. They'll go back in the jury with you, and you can see that those photos were taken through the front windshield as the cars were facing each other. Nobody's outside of their vehicles here. And how else do you know that? Because they're only 20 feet apart. Sheriff Troyer's got the phone in his hand, and yet on the 911 call, you don't hear any screaming or any yelling on that recording. You don't hear Sheriff Troyer opening this heavy door of a Tahoe and exiting it. The vehicle was running when the police arrived, and yet he says he's outside this door with the door open, and you don't hear any of the ding, ding, ding that a vehicle would make if you had the door open with the engine running and you're standing outside of it. You don't hear the sound as Mr. Sheriff Troyer is holding his phone and he pulls that heavy door from this large vehicle shut. You don't hear any of that because that's not what happened. And why is the defendant even allegedly getting out of the safety of his Tahoe in the first place if Mr. Altheimer had just threatened to kill him? And compare the very animated testimony of Sheriff Troyer when he testified, and he was describing the alleged actions that occurred almost 2 years ago by Mr. Altheimer, and the complete calmness in his voice when he's talking about those events on the 911 call minutes after they occurred. And the actual significance of the 1 or 2 cars is that that's not what you'd ask for if someone had just threatened to kill you. That's what you'd ask for if you just wanted some police cars to roll up and teach Mr. Altheimer a lesson. Now, another factor that you may want to consider when using your collective common sense and assessing credibility is whether each person's testimony makes sense. Is it consistent? Does it ring true? The statements that Sheriff Troyer made on the 911 call are about an event that just occurred. So memory shouldn't be a problem at that point in time. And keeping the truth straight for less than 5 minutes shouldn't be difficult. And as all of you know, it's easy to keep the truth straight when something happens, but it's difficult to keep your facts straight when you're not telling the truth. So what does Sheriff Troyer tell Mr. Shadle right after the event in question during this 5-minute call to South Sound 911? Well, here are the statements regarding blocked in. First words out of his mouth: I caught someone in my driveway who just threatened to kill me, and I blocked him in. Now, notably, that's consistent with Mr. Altheimer's testimony that after he leaves, Sheriff Troyer continues to chase him down and then blocks him in. That's consistent with Mr. Altheimer's testimony, not consistent with Sheriff Troyer's testimony. And then later, Sheriff Troyer says he knows who I am and he threatened to kill me and I got him blocked in. Later again, I got him blocked in. But then he also says, I'm trying to back up and let him go, but he blocked me in. And you can see on Officer Ventura's body camera how effortlessly and how far he was able to back up when TPD arrived when he really wanted to. He could have left at any time. After all, no one was chasing him. Later, literally blocked me in. Later still, he's not going to let me leave. These are his own words, and they can't both be true. Either you're blocking someone in or they're blocking you in. But he can't keep his facts straight. The driveway situation. I caught someone in my driveway who just threatened to kill me. He was in my driveway. He was in my driveway and I got in my car and he was in my neighbor's driveway. But then later on the call, I'm doing a remodel, there's not much room. There's no room in my driveway. So he tried everywhere else. These are his own words and they can't both be true. And in addition to saying contradictory things that can't both be true, Sheriff Troyer also says things to Mr. Shadle that show that his life was never threatened. And assessing credibility includes assessing the reasonableness and therefore the believability of a person's statements. When a dispatcher is sending officers to a scene, he or she needs to know what those officers are going to encounter when they get there. The responding officer's safety depends on knowing what threats and weapons exist. And as a police officer himself, Sheriff Troyer knows this. And he says he cares about this. And yet here's the exchange on that point between Mr. Shadle and Sheriff Troyer. Mr. Shadle, does he have a gun or anything? I have no idea. He looks homeless in his car. This isn't how a person whose life has been threatened and who cares about the safety of responding officers talks. Sheriff Troyer's tone and his words are dismissive of this critical piece of information. A piece of information that's critical to whether or not the responding officers are going to be at risk. And while the state does not need to prove motive, it's not an element of any of these charges, I submit to you that his tone, his dismissiveness, and this statement and other statements provides insight into why he actually called 911. He later refers to Mr. Altheimer's car as a homeless-looking sedan. He claims he can see belongings and a garage door opener, but not newspapers piled up in the back seat, or any features of the person driving the car. The next day, when he's asked through Facebook by his neighbor, Mr. Anderson, what happened to get such a big police response, Sheriff Troyer again says he was living out of his car, even though he knows definitively at that time that that's not true. And he claims that calling someone a porch pirate here without any evidence is not derogatory. And when asked about why all the police cars were there the day before by Mr. Anderson, Sheriff Troyer again never mentions a threat of any kind. But he does tell Mr. Anderson that Mr. Altheimer was anti-cop. And when he received a Facebook message after a civil lawsuit settlement from a man whose relative died in police custody, saying, "Your department got off cheap. Your men should go to jail. Your men should be going to jail." How does Sheriff Troyer describe that message from a deceased person's relative? I took it as a threat. Now, Sheriff Troyer's been very vocal about his belief that law enforcement is not given the respect they deserve, and having pride in your job as a law enforcement officer, and having pride in law enforcement and the people who serve under you, that is great. But thinking that a man who says your department got off cheap is threatening you, that's over the top. And telling a 911 dispatcher that the anti-cop person driving the homeless-looking car threatened to kill you when that's not true, that's a crime. And there's so much else about Sheriff Troyer's account here that does not make sense. Like that he told officers Hobbs and Lawless that he was asleep in bed. And yet, when he's on scene, he's still wearing work clothes, including a button-up shirt. You'll have the admitted exhibits back in the jury room with you, and you can hear Officer Hobbs on that body camera telling Officer Barron, "How'd he get in his car?" He said, "How'd you get in your car? You said you were sleeping in bed." That's what he told Officer Lawless, that's what he told Officer Hobbs, and yet he's standing there 2 a.m. in a dress shirt. How is it that he's lived in this neighborhood for 20 years and he's never seen Mr. Altheimer delivering newspapers, and that when he's 2 or 3 blocks away from his home, he has to read the street sign because he doesn't know where he is? He claims in testimony that he only followed Mr. Altheimer, or didn't even follow him, just went looking for him for 3 blocks. But notably, that Mr. Altheimer described seeing him, following him, and seeing him on multiple times on this very extended route that just happens to be the route that Sheriff Troyer takes when he's going home. That he claims he can see a garage door opener and Mr. Altheimer's pumped up muscles and the belongings of a homeless person in the back of the car in this dark neighborhood, but that he can't see a pile of newspapers, and that his story just keeps evolving. First, there was no threat. Then it was clear he wanted to fight. And now that Mr. Altheimer said he was going to take him out. But he didn't say that to Conrad Shadle. He didn't say that to Officer Hobbs. And he didn't say that to Officer Lawless. The collective evidence presented in this trial proves beyond a reasonable doubt that Sheriff Troyer knowingly lied to South Sound 911 when he claimed that Mr. Altheimer had threatened to kill him. The final element in false reporting, which is count 1, is that the defendant knew that the false report was likely to cause an emergency response. And then emergency response is defined in a separate jury instruction for you. So I've put up here that that's the third element, and then I've put up the emergency response definition, which you have in your jury instructions in a separate element. Now, emergency response isn't what you might have thought it was before you read this definition and sat through this trial. It doesn't have to be the massive response that was begun here. An emergency response under this law is simply any action to protect life, health, or property by a peace officer or law enforcement agency, here the Tacoma Police Department, of the United States, the state, or a political subdivision of the state. And this element is easily met here because when Sheriff Troyer called 911 to say his life had been threatened, TPD officers receiving that information took the action of rushing to his aid. And any action satisfies this element. So even when Sheriff Troyer asked for just 1 or 2 cars, which I submit to you are not the words of a man whose life has been threatened, that alone satisfies this element beyond a reasonable doubt. On January 27th, Sheriff Troyer weaponized the police force to settle a personal, petty score with a man who didn't treat him with the deference and the respect that he felt he deserved. I submit to you that the state has proven the charge of false reporting beyond a reasonable doubt and respectfully ask you to return a verdict of guilty to count 1. Count 2 is making a false or misleading statement to a public servant, and these are the elements. Again, Pierce County has been easily met, as we talked about before. And now, while the remaining elements of this crime aren't complicated in and of themselves, the statute's a little bit clunky to navigate, which is why I put this up here for you so that I can just walk you through how to navigate the statute. So let's break this down. Element 1 is that the defendant knowingly made a false or misleading statement to a public servant. Now, I've just gone through in great detail the evidence that shows that Sheriff Troyer knew that his statement that Mr. Altheimer had threatened to kill him was a lie. So I'm obviously not going to go through that again. But for false and misleading statement, this first element of this charge adds 2 things. First, that for this charge, element 1 is satisfied not only if the defendant made a false statement, it's the same as in the false reporting statute, but also if he knowingly made a misleading statement. It's a broader element there. And secondly, element 1 adds the requirement that the false or misleading statement be made to a public servant. And public servant is defined for you in a separate jury instruction, and it means an employee of government. And that public servant here is Mr. Shadle, the 911 dispatcher who initially took the call from Sheriff Troyer. Now, Mr. Shadle is a dispatcher with South Sound 911, which is an agency that provides law enforcement dispatching services for the county. He testified that South Sound 911 is a government entity, that he is an employee of that government entity, that he's paid with taxpayer money, and that he's part of the state pension fund. Therefore, Mr. Shadle is an employee of government and therefore a public servant. And Mr. Shadle isn't just any public servant. As a dispatcher, he has every on-duty police officer in Pierce County at his fingertips to send wherever help is needed. And that's a reality that I'll talk a little bit more as we go through the other elements. Okay. Element 2 of making a false or misleading statement to a public servant also requires that the statement is material. A material statement is defined for you. You see I've written in 2 is the second element, and then the bottom is the definition of a material statement, which is listed for you in a separate jury instruction. A material statement is a written or oral statement reasonably likely to be relied upon by a public servant, here Mr. Shadle, the dispatcher who took the call, in the discharge of his or her official powers or duties. And this element is easily met here because it's been proven not only that Mr. Shadle reasonably relied on Sheriff Troyer's statements, but that he actually relied on them. Because Sheriff Troyer explicitly said his life has been threatened, Mr. Shadle took those words, typed them into the CAD, and that's what initiated the highest priority response. So element 2 has been proven. Element 3, right there, is that the defendant knew both that the statement was material and that it was false or misleading. So element 3 is that Sheriff Troyer knew that his statement that someone had threatened to kill him was material, meaning he knew that Mr. Shadle was reasonably likely to rely on his statements. And it's clear for many reasons that Sheriff Troyer knew that his statement that someone had threatened to kill him was material, meaning that it was likely to be relied on. He's been a police officer for decades, including working the streets and being the PIO, and he knows how this works. He knows how to skip the comm person and get directly to the dispatcher to get police sent your way. And I don't mean to be flip about this when I say this, but another reason it's clear that Sheriff Troyer knew his statement was material, because quite frankly, that's just obvious. It's obvious that when an officer calls a 911 dispatcher and says that someone has threatened to kill him, that of course the dispatcher isn't going to hesitate to send all on-duty officers to the endangered officer, because every second matters. And if that's not obvious enough from just your common sense, consider the emotional testimony of Leah Heiberg, who testified that when she read on her screen that Sheriff Troyer said someone had threatened his life, she said, "I worked with Sheriff Troyer for 6 years. I was scared for him." So she activated the tone which triggered the highest priority tone out, and she sent everyone. And the reason she was crying, because she was remembering the times when officers had died, and how when an officer's life is threatened, you have to send everyone. And not just Leah Heiberg, but everyone else responded the same way. All 7 dispatchers, plus the 3 relief dispatchers that night, all dispatched their officers. Other officers, seeing this before they were even dispatched, attached themselves to the call and started heading that way. Officers from 19 law enforcement agencies throughout Pierce County, including the State Patrol and the Tribal Police, were either dispatched on the scene by one of these 10 dispatchers or attached themselves to the call themselves when they saw that a fellow officer's life was at risk. And that's why over 40 units began heading that way. Element 3, that the defendant knew that a statement was false or misleading, and that he knew it was material, has been proven. Sheriff Troyer knowingly made a false and misleading statement to a 911 dispatcher, Conrad Shadle, when he falsely claimed 4 times that Mr. Altheimer had threatened to kill him. Sheriff Troyer knew that his statement was a lie. He knew that Mr. Shadle would rely on that lie to send the police to confront Mr. Altheimer. And I submit to you that that second charge, making a false or misleading statement to a public servant, has also been proven beyond a reasonable doubt. When Sheriff Troyer lied to 911 that night, he put himself above everyone else, above the needs of every officer who rushed to the scene, above the needs of a community that has the same rights to have its officers available to them as Sheriff Troyer does, and above the needs of Mr. Altheimer and others who are trying to go about their business without fear and intimidation. All of the evidence, including Sheriff Troyer's own words and own actions, point in one direction and prove beyond a reasonable doubt that his claim that a newspaper carrier had threatened to kill him was a lie. The state has proven beyond a reasonable doubt that the defendant committed the crimes in count 1 of false reporting and in count 2 of making a false and misleading statement to a public servant, and we respectfully ask that you return a verdict of guilty to both counts. Thank you.
Thank you, Ms. Tratnik. Members of the jury, this is a good time for our afternoon recess. I'm going to go ahead and excuse you to the jury room. As you know, no talking about the case and no research about the case. And you can leave the instructions and your notepads on your chairs, that's fine. So at this time, the jury may return to the jury room.
Otherwise things get messed up out here and stuff. What?
The jury has exited the courtroom. Thank you. Everyone may be seated.
I just find it.
After the recess, is the defense ready to proceed to closing argument?
Yes, Your Honor.
Do you need any technology set up?
No,
Oh, okay. Because we were going to give you time if you needed to do that.
no, I appreciate
Right.
it, but no thank you.
Let's go ahead and return at 3:15. So the court is at recess. Thank you. Please be seated. Is the defense ready for the jury to return?
We are, thank you,
Is
Your Honor.
Is the state?
Yes, Your Honor.
Can you please bring the jury back? The jury is returning to the courtroom. Thank you. Everyone may be seated. And members of the jury, at this time, please give your attention to the closing argument of the defense. Ms. Bremner.
Thank you, Your Honor. And good afternoon. First, on behalf of Sheriff Troyer and our team, we would truly like to thank you for your sacrifice in serving on this jury. We know you spent a lot of time back in the jury room, and I'm sure you get along really well now by now. But we really just can't thank you enough for your duty, your service. We talked about it being a privilege, too, to be on jury duty, what Abraham Lincoln said, the highest duty. Privilege of citizenship is being on jury duty, but you are an extraordinary jury. So I want to start on behalf of the sheriff, his family, and our team. Thank you. As Sheriff Troyer said, the media has made him out to be a racist. The Attorney General's office has made him out to be a liar. Neither of those things are true. He has steadfastly maintained the same testimony throughout all of this horrible ordeal for him. As the sheriff, he's duty-bound to make the county safe. He's been doing this for 37 years. Starting out at age 22, as you heard, born and raised here and became a police officer, a sheriff's deputy, and the PIO, Public Information Officer, for decades, and ultimately the sheriff elected within just a couple of months of this incident. The only thing you heard from the state to attack his credibility was about a Facebook page from about 10 years ago about some kind of a conflict with somebody. Remember, I asked him and he said, I haven't had any complaints, sustained complaints, filed complaints in all my years for racism, race discrimination, sexual harassment, abuse of power, or any kind of abuse, And they've never contradicted that. That's a long time to be a sheriff's deputy, the PIO, and then the sheriff himself, and to have such an amazing record. You also heard that he has a family. Wendy's still here. She testified and got emotional about this because this has really impacted all of them. The department, his family. They've raised a lot of foster kids. They even had one for 10 years that was a quadriplegic that they took care of. They've adopted a number of kids, very wedded to their community in the county, to the citizens of this county, and to the members of the department. So why are we here? Talked about a waste of resources, we just heard from the state, that he somehow allegedly wasted resources. I'd submit to you that this trial is a waste of resources. Huge waste of resources. Because he didn't do anything wrong. He didn't commit any crime. They talked about a massive response from the police personnel from Tacoma Police, and we know it wasn't massive. We've heard all the testimony in this case. Ed only asked for 1 or 2 cars. I'd submit to you what is more massive here is their attempt at injustice against an innocent man. This is a wrongful prosecution. plain and simple. A wrongful prosecution against the elected sheriff of your county. Officer Hobbs, I have to come back to him from the beginning. I'll probably end with him. He had a body cam. He saw the conversation between Sheriff Troyer and Officer Lawless. That is the only reason that they filed this case, purportedly, or the main reason.
Objection, irrelevant and not true.
Overruled.
Thank you, Your Honor. So he was the only one, and he's witnessing what Lawless is talking to Troyer about and vice versa. And what was a very short conversation. And he said on the body cam that the sheriff had said he was threatened. So why are we here? That's the centerpiece of their case. And Officer Lawless, who said there was no threat. The threat was walked back. This was retracted. I asked Troyer, he said he wasn't threatened. That's over here, and I'll get into the other reasons why that's not credible, what he has to say, not persuasive. But we have an eyewitness, Officer Hobbs, who actually captured that on a body cam. And he was a great witness. And you heard what was on the body cam. It's captured there. All Sheriff Troyer did was ask for 1 or 2 units in a situation that was really simple. The state started their case by saying this is a simple case. It is simple in some ways, because let's look at what happened on January the 27th of 2021. Like any officer that sees something suspicious, or any of us that see something suspicious, you might investigate further and look to see what's happening. That's what Sheriff Troyer saw. Outside his window, a car, lights off, going in and out of driveways. And he simply followed. And it wasn't a matter of all the blocks you saw in that big diagram, remember, that we had up there? It was simply like 3 blocks that he followed the car. The lights were off. He could not see the race of the person in the car. And the person in the car couldn't see him because he had tinted windows, double tinted. And it was dark out and there's no street lights. He saw suspicious activity, and he basically was trying to see what was happening. Could it be kind of an issue in the neighborhood of thefts, break-ins, whatever that looked suspicious. At that point, Mr. Altheimer, when he was right behind Mr. Altheimer, gets out of his car and confronts the sheriff, as you remember. And he's mad, and he's yelling, and he says, "I'm going to take you out." Now, he says he's been pulled over 10 times before by the police, Mr. Altheimer. And we don't know what happened in all those times. But why, on this occasion, did he get so mad and confront the sheriff? I mean, what was he thinking? Why did he do it? We don't know. All we know is that he got very, very angry, and the sheriff was shocked. He stayed in his car, and he called an inside line and asked for 1 or 2 cars. That's it. He didn't ask for 40, 43, 46. He asked for 1 or 2, and you heard him on the tape. I played it for you when he just testified yesterday and Thursday. And the reason he repeated that there was a threat was because you're asked to stay on the line until the officers get there. So he's just repeating and also seeing if the dispatcher is acknowledging that he says there was a threat. Once that's acknowledged, they talk about other things. So that's what happened on the 27th. There was no arrest. There were no guns drawn pointed at Mr. Altheimer. No racist, no claimed racist comments. No use of force. No abuse of authority. None of those claims by Mr. Altheimer. Nothing whatsoever. Was this a misunderstanding with Officer Lawless? I'll get to that. But there clearly was a threat. The communications folks were disciplined, remember, because they didn't put in the information about 1 or 2 cars. And so sheriff just calls in and says, "I need 1 or 2 cars." If he wasn't if he hadn't said there was a threat, you know, he's the sheriff, he can call in for any reason, and they're going to come out there. Any reason whatsoever. Just, I mean, think about that in this case. That's been charged in this case. He can just call, "It's Sheriff Troyer. I need a car. I need a couple cars." They're going to be there like that. Is that a crime? Obviously not. This has been called a he said, but it isn't, because the prosecutor just asked you, like, why, Mr. Alzheimer wouldn't do this. He was going about his business. He's just delivering papers, et cetera, et cetera, et cetera. Let's look at Josh Harris, who went through the exact same thing that the sheriff went through, when we look at whether or not Mr. Alzheimer would do this, because he did. So in our case on the 27th, he threatens the sheriff, and the sheriff does exactly what he should do, call it in, stay in the car, and let other officers know this is dangerous, potentially, if you come here. You don't want the officers coming into harm's way. So from that, we have Josh Harris. And really interestingly, he's driving, he sees suspicious activity, just like the sheriff did, and he follows Mr. Alzheimer. Remember this testimony. He was a short witness, but really an important witness. He follows Mr. Alzheimer. Mr. Alzheimer becomes enraged, claims racism. He also takes a newspaper under his sweatshirt like he's got a gun, threatening him. And Josh Harris felt threatened. That was just an encounter with a citizen. He'd seen Mr. Alzheimer in the driveway of his 90-year-old neighbor's house and wanted to see if there was an issue. It was late at night, etc. Almost identical to what happened with the sheriff. And the threat to kill, you bet if it looks like a gun. That's more of a threat to kill than I'll take you out, I'd submit. But it doesn't end there in the similarities because, as you remember, Josh Harris said that Mr. Alzheimer came back to his house at 3 in the morning, banging on the door and saying that, is this my microphone? Oh, I don't know how to do that, but
Yeah, I'm also going to object to improper use of impeachment testimony.
I think it's the same. Okay. Okay, thank you. So
Overruled.
I'm sorry, Your Honor.
The state made an objection, and I overruled it.
Thank you, Your Honor. So Mr. Alzheimer had gone back to Mr. Harris's house, banging on the door, 3 in the morning, and then left a newspaper saying "F you" in it, a little slip in it that said "F you." Same kind of threatening kind of behavior, including looking like he had a gun. Remember, Mr. Harris said he had a gun. Mr. Harris had one in his lap. So take a look at that, and then take a look at what happened to the sheriff when you look at corroborating evidence. And the prosecutors claim that Mr. Alzheimer wouldn't do this. He was just doing his job, going about his business. Lightning doesn't strike twice. This is exactly what happened with the sheriff and with Mr. Harris. The corroboration also for what Sheriff Troyer has to say is this, and you really have to think about this with common sense. The prosecutor just talked to you about common sense. There's a couple of quotes on common sense. One is, if a man has common sense, he has all the sense there is. You're asked as a jury to use your common sense. Remember, we talked about that in jury selection. Using your common sense. You don't leave it hanging in the closet like a coat when you come into jury duty or into the jury room. But also the part of it is, trials are almost like organized combat. And there's a quote that in any war, the first casualty is common sense. And this case is about common sense. Why would Sheriff Troyer make this up? Think about it. Why would Sheriff Troyer lie? That's what he's charged with. And say that he was threatened by Mr. Alzheimer. For what purpose on God's green earth would he do that? There's absolutely no reason he would ever do that. You have to use your common sense in terms of what they've charged here. These are crimes they charged. Serious crimes. So it's a he said with Mr. Alzheimer, but it isn't, because we already have corroboration. He's done this before. with Josh Harris. But there's more in terms of why you should believe the sheriff and not Mr. Lawless or Mr. Altimer. But let's turn to Officer Lawless. So he's saying, I guess, that I asked the sheriff he was threatened and he said no. And he's remembering that all this time later, supposedly. And then, even though Officer Hobbs completely contradicts him, and like I said in the opening statement, the only substantive real evidence of that conversation is the body cam of Officer Hobbs. That's what you can rely on. Not the say-so of somebody all this time later when it's really defective testimony. There is a line that witnesses can and do lie, or they can be mistaken, but the evidence never lies. Evidence doesn't lie. It is what it is. And you have that evidence here that the sheriff never denied being threatened. So it's over. I should stop talking. But that's what the evidence is. And let's look at Officer Lawless now in terms of why what he has to say shouldn't carry the day or shouldn't carry any weight to you here. And we're not calling him a liar. We're just saying he's mistaken and there's certain circumstances where you shouldn't accept his testimony. He took the Fifth Amendment 400 times. That meant he 400 times said, any answer I give will incriminate me criminally. You know, what's most important on that is he took the Fifth Amendment, and this, I'm just going to hold up the state's exhibits, as to whether Exhibit 19, which is the police report that he filed the next day, he took the Fifth Amendment on whether or not that was an accurate police report. That's what they're relying on in this case. But there's more, or there's less, depending on how you look at this. He did not want to write a report, remember? He wrote it the next day. He closed out this case on the CAD. We heard that, or saw that in the CAD. But then the next day, Lieutenant Blair had him write a report, so he did it. He had very little information in there from the sheriff or any other kind of information you need in a police report. It was just kind of a cursory report. And then he was part of a group text where he showed some animus against the sheriff, where he said, referred to the sheriff as, and these are not my words, bitch and a douchebag in a group text. Now, what the sheriff said is, when he talked to Lawless, the sheriff said, I'm just not worried about it, about the threat. That's far more credible. This is a timeline, where he basically had suspicion about Mr. Altimer, and that suspicion changed once he learned that Mr. Altimer was a paper carrier. I mean, I could use an example. Last night I was getting ready to give these remarks, and I was sitting facing away from my windows, and I heard some sounds. And it sounded like somebody was in trouble. Even my cats got up with me, which takes a lot for them to do anything. But I got up, and I thought someone was in trouble, and it was actually like dogs squealing in a fight. So my suspicion was somebody needs help. As soon as I got to the window and I could kind of see and listen more closely, I'm like, oh, okay. That's the same thing as here. He had suspicion, it changed, and then he let Mr. Altimer go. They say either Eleanor Roosevelt said this or Claire Booth Luce, but no good deed goes unpunished. That's what happened here. He let him go. He could have said, investigate him, he threatened me. That's a crime, harassment. He could have done all kinds of things, but he didn't. He said, and I'm not remembering the sheriff's exact words, but he said, something like, oh, he's a paper boy. Let him go and do his job, I think is what the sheriff said. And so that's what happened. That's what he did. That's the whole case. Officer Lawless was supposed to have a body cam on. He didn't have one on. If he'd had one on, that'd be a different story. because there's a conversation between three people, Officer Lawless, Officer Hobbs, and the sheriff. And Officer Hobbs recorded what was said. Officer Lawless didn't. He also the comments on the group chat, he tried to explain this is like a house of cards in a way, because you're basing everything, or they're basing a lot on Officer Lawless, where they can't. They simply can't. What about Mr. Altimer? Let's just talk a little bit about Mr. Altimer. He'd been stopped 10 times before. He said every time he was stopped, he said it was because of race. He said in this case, he was stopped because of race. He said in this case, I asked 3 questions. I don't know if you remember what he said, but he said, are you a cop? Why are you following me? And is it because I'm black? He said, I asked those 3 things of the officer, of the sheriff. If you believe that he asked those 3 things and nothing else happened, then that would have been a non-event. And we wouldn't be here. There wouldn't be a call for backup. If he's just asked 3 questions, and the sheriff either didn't answer or there was no confrontation, we wouldn't be here. But that's not what happened. He got into confrontation with the sheriff. And then how else do we have corroboration for that? Officer Ventura's body cam. You saw it again the other day. I mean, he's very agitated. He's dropping F-bombs. He's very upset and very angry. And that corroborates the way that he acted with the sheriff. But then he was that way again. This happened at 2 a.m. He was that way again at 4 a.m. when he went back to the sheriff's house. And you have to ask yourself, how did he know where the sheriff lived? But that's not a question. He went to the sheriff's house and grabbed his engine and started yelling at the sheriff's house at 4 in the morning. And he's still as mad as he was at 2 in the morning. And then he hurls a newspaper. Going back to Officer Lawless for a minute on that, Officer Lawless basically was called on that through a sergeant. He just poo-pooed it, talked about a malicious throwing of a newspaper, which isn't a crime. But Mr. Altimer was really mad still at 4 in the morning. Where was he at 5 in the morning? Remember? Talking to his aunt, Kim Brown. And he was still as mad at 5 in the morning. And she testified that he was extremely angry, yelling, and she said he just doesn't listen to anybody. And his feeling is like, you should just show your newspaper or tell him you're a newspaper carrier, or maybe it'd just be better if you say I'm a newspaper carrier, it would all go away. And he feels like he doesn't have to. He just feels like he doesn't have to. If he had just said, I'm delivering newspapers to the sheriff, it would all have been over. Just said that. So, Mr. Altimer, in terms of his credibility, he said guns were pointed at him. They weren't. And he said he had asked those 3 questions and didn't confront the sheriff. That's wrong. Remember, he said he wasn't the aggressor? But you saw up on the easel when we showed it with the sheriff, I can't remember which day, yesterday. It went like this. It went about 3 blocks, and then the sheriff is behind Mr. Altimer, just like this. And then there's a confrontation. But Mr. Altimer actually moved around to turn around and face the sheriff's car. And there was some blocking in on both parts. But the important thing is Mr. Altimer was the aggressor and came up to the sheriff's car. He also said on the Ventura tape that he knew he was a cop. Called him Sheriff Ed. He had 4,000 complaints in his work in about 2 years. That's quite a few a day. And he also said that on a GoFundMe page that he said he wasn't involved in and he'd thrown out the flyers and things for. We heard from a witness, Ms. Guzman, the first witness we called from the neighborhood, that he had actually put those GoFundMe flyers in the newspapers that he delivered. So that was a lie. He said the neighborhood was only white. It's false. Very diverse, as you've heard. He said that he almost got shot, almost died, and that's not right. Even his aunt, Kim Brown, said that she reviewed the video, maybe it was Ventura's video, of what the police did, and she thought they did a really good job.
In fact, not in evidence. Objection.
Sustained.
You saw the video. He was treated very well. In fact, the de-escalation of the situation by Officer Ventura was incredible. Textbook. He filed a claim for $5 million. It's a lot of money. And the reason we brought that up is because it shows that he has a financial bias. He goes to his credibility. And it's pretty basic. I mean, if somebody files a lawsuit for $5 million, then it's connected to this case. It shows his financial bias and comes into play when you evaluate his testimony and what he claims to have happened to him. He said that, remember we had two maps. We had the map, the big map up here, that he drew a pretty long, Mr. Altimer drew a pretty long route. And then we had the smaller map of the sheriff that we put down here that showed about 3 blocks. And remember I asked Mr. Altimer when he was on the stand, well, those maps are really different. And can you explain the difference? And remember he said, well, one of us is lying. And in looking at that, on who's lying, he said that he saw the sheriff far away, relatively far away from the sheriff's home and far from Deidre's circle on the route that he drew for you, but he couldn't have. The sheriff had the double-tinted windows. He couldn't have. And so that whole convoluted route, not convoluted, but longer route that he's drawn here is not right. It's not what happened. He wasn't being truthful. He also said that he had been by the sheriff's house at some point. He knew it was the sheriff's house because of exempt plates. But the sheriff never had exempt plates in his car at his house. Again, false. He said that there was a ring camera at the sheriff's house. False. There was only a ring camera after the protests that came from this case. Long after the incident, not before. He could have just said he was a newspaper carrier. He could have had a sign. He could have just waved the paper out the window. But his response has been, I don't have to. But that doesn't mean the sheriff should be charged criminally and be sitting in a courtroom like this, charged with serious crimes. Serious crimes. Going through a few things that were raised by the state and also about pertaining to Officer Lawless. He didn't take notes at the scene. He was primed for a priority call. No one was running to their cars. This was not a call to arms or massive response. But he clearly poo-pooed the situation to a certain extent when he had the group chat. I think we can say that. He also poo-pooed this person, Altimer, returning to the sheriff's house with a newspaper and yelling and rubbing his engine. But And that's why he just drove by. Remember later on? He was responding, but he just drove by the house and didn't investigate. He didn't take notes, didn't write a full report, didn't have a body cam, wrote about the sheriff, but importantly too, he said, in those notes, the group chats, he said, and he thought this was private, he said, once this became public, this case, I'll have to testify to what my report said.
Objection, fact, not an evidence.
Overruled.
So he was locked in back then. The case was big in the press. And remember, it didn't come in through a case, it came in through the Seattle Times. And it was a big case. And all of a sudden, everybody involved is texting each other, right? And saying, you know, wow, this is big. And he says, I'll have to testify what's in my report. That's Exhibit 19. Also, when he took the Fifth Amendment after charges were filed, he tried to avoid answering the defense questions, but not the prosecutors. He also, of course, took the Fifth to questions about his report being accurate and whether Ed denied being threatened. Took the Fifth Amendment, feeling that he would be incriminated criminally if he answered. He said he testified he did that out of concern. His answer to the questions would expose him to criminal liability. Going on to Officer Hobbs. On his body cam, Officer Barron asked him, what did the sheriff say? Hobbs then began reciting what Ed told him, including, at one point, he said he threatened to kill him. He, meaning Alzheimer's. It's right there on the body cam in response to a question from Officer Barron. And then Hobbs testified that the we he referred to was he and Lawless, confirming he was present for the Lawless Ed Troyer conversation. He meant when Lawless came over and asked what happened, Ed never denied being threatened, mentioned threats. So it's very clear that Ed Troyer never denied being threatened. And that's the basis for the state's case, the Attorney General's case. Mr. Altheimer clearly wanted a confrontation. He'd been pulled over many times for driving suspiciously in a similar manner. That's what he said, based on the way he drives in his route. He also said he had seen the sheriff on TV. He knew who he was. And he said, I see his wife leave for work every day. Right after the incident, he knew exactly where Ed Troyer's house was. That's where he showed up revving his engine, yelling at the house and throwing the newspaper. His purpose there was clear. He wanted them to know that he knew where they lived. He wanted to intimidate them. The lawsuit against Pierce County for $5 million is also against Ed Troyer, personally. Mr. Altheimer's financial motive is enormous. The state needs to show, to prove a crime here, that Ed Troyer knowingly made a false statement. What matters is what he subjectively understood Altheimer to mean when he said, I'll take you out. Remember, he quoted President Biden when there was an arrest or a killing of a terrorist. And then President Biden, in a press conference, said, I'm paraphrasing, if you mess with the United States, look what happened here, we'll take you out. It's the same thing. So the question is, did he knowingly make a false statement? And did he subjectively understand Altheimer to mean when he said, I'll take you out, that was a threat to kill? He testified that's how he interpreted it under the totality of the circumstances, including Altheimer's aggressive posturing and approach as a threat to kill. And also, he reported that threat to one of other officers, as I said. It doesn't make common sense that Altheimer calmly walked over and asked Ed why he was following him, and then Ed called the police for no reason and made up a threat. Why would he do that? State has no explanation for what Ed's motivation would be in making up a threat to kill. To get him in trouble? Then why would he say in the same call he only wanted 1 or 2 people or 2 cars? Or that it was no big deal? Ed is a sheriff of Pierce County. Under these circumstances, with a suspicious vehicle, an unknown person confronting him, he has no need to make up something to get 1 or 2 units to respond. He could probably get 1 or 2 units, like I said before, to get just about anything he wanted. As a sheriff of Pierce County, managing a depleted police force, constantly struggling to cover assignments, Ed, out of anyone, would never make a false report to initiate a needless emergency response. The idea he would purposefully waste police resources makes no sense. So what is reasonable doubt? You've got the jury instruction. The state has the burden of proof. The burden of proof beyond a reasonable doubt, of course, is the highest burden in our system. And the states, I'll give you some examples, of what it means being back in the jury room of having a reasonable doubt. Here's one. If you find yourself back in that jury room wishing there'd been a recording of the interaction between Altheimer and Troyer, you have a reasonable doubt. Or if you find yourself back in the jury room wishing Lawless or Hobbs has body camera on, you have a reasonable doubt. Or this, if you find yourself back in that jury room saying, I think this probably happened, or I think this happened, then you have not been convinced beyond a reasonable doubt. There's no requirement that you all agree. In fact, the court has instructed you that you may not vote to convict as long as you have a reasonable doubt. You may not change your vote simply to make a consensus. If you have a reasonable doubt, you must hold firm. We talked about, in jury selection, some general things, but how do you decide credibility? Can anything in nature be sliced so thin that it doesn't have two sides to a story? How do you judge who to believe? I hope I've given you some tools here to look at who to believe in this case, because this case, it is a travesty, it's a tragedy for the sheriff. And I'll probably later tonight think, oh, I wish I would have said this or said that to the jury to let you know how important this case is to him and how innocent he is. And to be sitting here as the sheriff of the county in a criminal courtroom in that chair is Kafkaesque. It's surreal for him every day. Every day. Remember Kafka, the trial, he didn't know why he was on trial or what he was on trial for. It was a bad dream. And just looking around every day like surreal, Kafkaesque. I can't believe this is happening to me. That's what's happening to him. He has spent, all of these years serving the citizens of this Pierce County, and of course as a PIO and a sheriff's deputy and as a sheriff, helped so many people. The Susan Cox Powell case, Chuck Cox has been here every day for him because the sheriff was there for him every day when he lost his grandkids in years of tragedy. The Lakewood Four, the kinds of cases he's dealt with. He's here to keep everybody safe. He's been active in the community. Everyone down there believes in him. He's got the corrections officers. He's got the courthouse. He's right downstairs. He's got all the sheriff's deputies. He's a good man. He's a great man who deserves not this for sure. Like, he'll get past this. But this prosecution's wrongful in so many ways. Let's turn to what the state tried to do to him on cross. I'd submit to you that they didn't lay a glove at him, as they say. After all of this sound and fury, it's a Shakespearean quote, signifying nothing, but after all of this talk about a lie, and this massive response, and all of the drama that they put into this case, all the money they put into this case, all the personnel they put into this case, cross-examination was maybe 20 minutes, half hour, and consisted of the following. You were asleep, Sheriff Troyer, before you encountered Mr. Altheimer. That's in Exhibit 19, this report. And he said, no, I wasn't. We already know about that report, Officer Lawless, and credibility. That was first. Then second was really minutia of going into a CAD, going to Times, and saying exactly at this second you were backing up, or at this minute you said this, but you really were over here. That was a long time ago. Frankly, none of us remember things like that. Frankly, none of us remember conversations that are really small and short that aren't of consequence at the time, i.e. Officer Lawless. So she asked about that, and then the next thing was this couple of things from Facebook, and you heard the sheriff, I think he said Facebook is not my friend, but he, there was the one thing about something on Facebook. It was not a formal complaint, it was not a sustained complaint in Internal Affairs, just a Facebook post from like 10 years ago. And then another one with his neighbor, where the neighbor says, there was a lot of police activity. What's going on? What was happening? And the sheriff responds with a pretty general narrative saying, there were police here, etc. I don't remember the details now, and it was testified to yesterday. But it was basically, the state asked, well, you didn't mention a threat in there. Well, why should he? To his neighbor? His neighbor just wants to know from the neighbor sheriff what happened. Right? And you're not going to say, by the way, I was threatened. You're just going to say, it's handled. This is that was what you saw, and, it's over. Otherwise in the cross-examination, nothing. He was firm, steady in his testimony, and you know why? Because he was telling the truth. And the state didn't have anything to impeach him with. They didn't have anything to show that he was a liar, as they called him. They didn't have anything. Absolutely nothing. They had all the personnel, documents, anything they could put their hands on, and they didn't lay a glove on him. But that's because he's not lying. He's charged with lying, but he's not lying, and they couldn't show it. It's impossible because he's telling the truth. There was some limited testimony about how things progressed once the case was in the Seattle Times. And eventually there was a letter mentioned from the governor. And then there was a prosecution from the Attorney General's office.
Motion in limine repeatedly violated.
No, Your Honor, it was,
Overruled.
thank you, Your Honor. And so the Attorney General's office took on the case, and they said they wanted to talk to Ed Troyer. But he had a lawyer and declined to get into basically what you saw in the cross-examination. These prosecutors took a movement, and it's a laudable movement, that we saw during the time that these events transpired, that really seized our nation, involving law enforcement and race. They took that movement and they put it into this case.
Motion in limine.
Sustained.
Ed is a law and order guy. We talked about in jury selection, he shouldn't be tried in the median. He'd be tried right here. He's a clear-eyed, plain-spoken sheriff. He called it as he saw it at the time, and he was threatened, and he was truthful. You've heard from his wife, Wendy, how this has devastated her family and changed the way they gather, the way they live. They're prisoners in their own home, and that's been true for the last year and a half. Like Sheriff Troyer said, if he was part of this investigation instead of the target of the investigation, we wouldn't be here. but getting information that I've just mentioned, he never got a chance. And he said, I'm going to let the jury hear the facts and decide. You know, I know it's been a privilege and honor for you to be here. It's been our highest honor and privilege to represent the sheriff of Pierce County. So I'm gonna end there, but he's not guilty. He's a good man. And ask you to find him not guilty and free him from all of this. Thank you.
Thank you, Ms. Bremner. Is there sufficient time in the day for rebuttal closing?
There is, Your Honor, I don't need long, it might go slightly past 4:15, but I don't argue.
Members of the jury, please give your attention to the rebuttal argument of the prosecution, and they get to go last because they have the burden of proof. Ms. Tratnick.
Thank you, Your Honor.
We get everything.
Very briefly, just to touch on some of the points that they've gone into. Again, several things are important to remember in the jury instructions, which is the evidence in the case is what you get to look at, not the statements of the attorneys. Those are not evidence. And a lot of times in life, and when you come to a criminal trial, you want to be looking for a good guy and a bad guy. But that's not the way it works. This isn't about a good guy and a bad guy. It's not about what either party has done with their life or all of the good things that Sheriff Troyer has done, which they have repeatedly brought in front of you as a shield. It has nothing to do with the elements of this case. The only thing you're here to determine is what happened that night. Did Sheriff Troyer lie when he said that Mr. Altheimer had threatened to kill him? And all of the good things he's done before that and after that, don't take away from that. But you're only here to determine not if he's a good guy, not if he's a bad guy, but did he violate the elements of this crime? Now, the state isn't required to provide an explanation as to why he did what he did, but there is ample evidence here as to, again, not argument, but evidence as to why he did this. He testified trying to read my own writing here. He testified in court. So a defendant is presumed innocent, but he's not presumed credible. And he testified here in court. I think he wanted to take me out and fight or get me or kill me or something. Or I don't know, he was so angry. He testified in court that he didn't know what Mr. Altheimer meant when he allegedly said he was going to take him out. And then when he calls 911, he never says, can you bring some people here to calm this down? There's a guy here who's really upset, and he says he's going to take me out. I just need a few people to calm him down. He never says any of those things. We don't hear about take me out from Officer Hobbs, Officer Lawless, or anywhere in the call. We don't hear about that until we get to court, where he then admits he's not even sure what that meant. And yet his words on 4 occasions to dispatcher Shadell is he threatened to kill me. He said he was going to kill me. Unambiguous words about what sent all of the police their way. That is a lie. And now we don't have to provide an explanation, but here there is a lot of evidence as to why. When asked about a weapon, he refers to Mr. Altheimer being in a homeless-looking car, a homeless-looking sedan. He claims that he can see belongings in the back, which isn't supported at all.
This is beyond the scope, Your Honor.
Isn't supported at all by the evidence that he can see these belongings, and yet he can't see anything else that's going on in the car. He thinks that Mr. Altheimer is anti-cop. He makes that statement to Mr. Anderson the next day, where he never recommunicates a threat. Why were all those cops there? Well, because the guy was anti-cop, and he was driving a homeless-looking car. Even the next day, when he knows that none of that information is true. He keeps talking about the Lakewood 4 and trying to invoke and exploit that image in front of you, an image that affected the testimony of Ms. Heiberg. But remember, we wouldn't even be here if he had just left. There is no dispute here on certain points, one being that when him and Mr. Altheimer had their first encounter, that Mr. Altheimer left, and he didn't. So when he invokes the names of these officers, the officers who rushed to the scene here wouldn't have even been involved and put in any kind of risk here if he hadn't lied. He's attempting to use them as a shield. When he was asked on the stand, Sheriff Troyer, if one of your men and women called a 911 dispatcher and said someone had threatened to kill them and they knew that person was a cop, wouldn't you want them to send everyone? I had to ask him 3 times. He wouldn't answer that question. And when he finally did, he said no. And you know that that is not credible. Of course the sheriff cares about the men and women who work under him, and yet when he thinks that the answer to that question might hurt his case, he says no. That's not credible. He's presumed innocent, but he's not presumed credible. During a 5-minute call, he repeatedly contradicts himself over and over again. He doesn't say any of the things on that call that he says now. I just need someone to calm things down. He looks mad. He looks like he wants to fight. He never says any of those things on the call. And asking for 1 or 2 cars, that doesn't help his case at all. If someone is threatening to kill you, you don't ask for 1 or 2 cars. The dispatchers knew that. You know that. Everybody knows that. He asked for 1 or 2 cars because his life had not been threatened. And remember the dispatcher, Mr. Shadle? When I did hear 1 or 2 cars, it didn't affect what I did at all. Because when someone threatens the life of an officer, we send everybody. What I also heard in closing is that this appears to be everybody's fault except Sheriff Troyer's. It's Mr. Altheimer's fault, because even though Mr. Altheimer tried to leave, he didn't volunteer that he was delivering papers. So it's his fault, even though he left and he was again followed by the sheriff. It's the dispatcher's fault, because they didn't put in 1 or 2 cars. It's their fault, even though Mr. Shadle said 1 or 2 cars wouldn't have affected how this was handled by me or anybody else. It's Officer Lawless's fault, because when he ran, him and Ventura and Hobbs and Barron all testified, they ran to the car to save the life of a fellow officer. And it's his fault for getting a body camera in the Charger that he wasn't even required to wear at that time. The testimony that Officer Lawless didn't take notes, incorrect. He testified that he did take notes, and it is absurd to believe that 24 hours he couldn't remember a conversation about one point and one point only, which is when I talked to Sheriff Troyer about the one thing that mattered in this case, were you threatened? He told me twice no. And the reason he asked him twice is because when he heard it the first time, it seemed so completely absurd. Of course he remembers what happened. Of course Officer Lawless wasn't going to get this wrong. Everybody went to this scene thinking the sheriff's life had been threatened with death. Officer Lawless isn't going to treat that as anything less than the priority zero call that it was. He got it right. And then, he took his attorney's advice and invoked, when he was brought into this high-profile case that he didn't want to be a part of, none of the other officers wanted to be a part of, he said his attorney told him that he had done absolutely nothing wrong here, but that he should invoke his right to remain silent,
Object, Your Honor, this
and that
assumes-
the law,
Objection assumes facts not in evidence, that the attorney said he'd done nothing wrong.
he did say that,
No, overruled. That's overruled.
told him he'd done nothing wrong, but you should invoke anyway. And the legal requirement communicated to Officer Lawless that you have to invoke for every question, every question. And now he's being criticized by a fellow officer for following his attorney's advice. Looking at the police report, there's Sheriff Troyer's name, but with no identifying information. He didn't take any notes, but he did take notes, which were then destroyed in the normal course of retention business. Officer Ventura was asked about taking notes. Watch the video. The only time that Officer Ventura took notes was that one occasion where Mr. Altheimer was giving his identifying information, date of birth, name, spelling. It's the only time Officer Ventura took notes. The note-taking thing has nothing to do with whether or not Officer Lawless got this one important question right. And you saw that when we talked about exhibits in courts here, everybody danced around them. Remember this photo of the car, Sheriff Troyer's SUV? The defense was like, it's got his license plate. We need to black that out. We asked the officers, when you returned later without telling me the address, whose home did you go to? This is information of a public official that wasn't put in the report. It wasn't necessary, and it's not supposed to be put out there in a public way. Now, when you're part of a team, any team, you have to have each other's backs. You know this from sports, you know this from work environments where you've been part of a team, but that is especially true if you're part of the military or if you're part of the police, where being part of a team means you have to have each other's backs. Your life depends on it. That's why Officer Lawless didn't get it wrong, and that's why Officer Lawless and Officer Barron felt betrayed by Sheriff Troyer. They were asked, why did you call him a bitch? Why did you call him a douchebag, right? It's because of his actions got us all pulled into this. They felt betrayed, but that doesn't impact the credibility
Your Honor,
of their
I object,
testimony
Your Honor, assumes facts not in evidence.
Overruled.
and how horrible it must have been for these officers to get pulled into this courtroom under subpoena and have to testify against one of their own and cross the blue line. So this isn't about a good person or a bad person, and it's also not about following somebody in a neighborhood or keeping an eye out for your neighborhood or being a good neighbor when you see something that concerns you. Nobody's saying that you can't do that. Nobody's saying you can't be part of a neighborhood watch group or keep an eye out for your neighbors, or even follow a vehicle that gives you concern. No one is saying that. And that's not what he's on trial for. He's not on trial for that. He's on trial for lying about what happened here. Last comment is on the body camera. Body cameras were not even required at that time. They didn't even exist a few decades ago. The way that cases are determined is by listening to the testimony of each witness, determining the credibility of each witness, and seeing if that is enough evidence to prove the case beyond a reasonable doubt. And here it is. The fact that some other piece of evidence exists doesn't change the burden of proof. It's either met or it isn't. And the state submits to you that it has been met and asks you to return a verdict of guilty to both counts. Thank you.
Thank you, Ms. Chapman. Members of the jury, you're going to be excused for the day, and you've heard this instruction before, but it's always been important. It is very important now. Please listen to what I have to say. During this recess and every other recess, do not discuss this case among yourselves or with anyone else, including your family and friends. This applies to your internet and electronic discussions as well. You may not talk about the case via text messages, email, telephone, internet chat, blogs, or social networking websites. Do not even mention your jury duty in your communications on social media such as Facebook or Twitter. If anybody asks you about the case or about the people or the issues involved in the case, you are to explain that you are not allowed to discuss it. Do not allow anyone to give you information about this case, including in your electronic communications. If you start to overhear a discussion or receive information about anything related to this case, you must act immediately so that you no longer hear or see it. If you become aware that you or another juror has been exposed to outside information, you must privately notify the court clerk. Do not discuss these matters with the other jurors. Do not read, view, or listen to any report from the newspaper, magazines, social networking sites, blogs, radio, or television on the subject of this trial. Do not conduct any internet research or consult any other outside sources about this case, the people involved in the case, or its general subject matter. You must keep your mind open and free of outside information. Only in this way will you be able to decide the case fairly based solely on the evidence and my instructions of the law. Please return to the jury room by 8:30 tomorrow morning, and when you do, do not begin discussing the case. I will bring you back in the courtroom, and then we'll talk about when you can start discussing the case. So what I've just read to you applies until you're back in court and I tell you that you can begin deliberating on your verdict. So have a great evening. Thank you for your attention, and you're excused at this time.